Friends, how are you doing? In this episode, I want to share with you the three priorities for ICE enforcement and the seven different ways that ICE can help you when you have a removal proceeding. Stay tuned all the way to the end of the show and you'll get the secret code. Friends, welcome to Green Card Guys TV. I'm your host, John Ting. I practice immigration law all across 50 states of America and across the world. Now, here to solve your immigration problem. Now, number one thing you need to know is what are the enforcement priorities for ICE? Now, this is something that a lot of private immigration attorneys and people who work in nonprofits are very excited about because this reminds us of President Obama. Now, politics aside, yes, generally, of course, Democrats during this past 20 years are more favorable to immigrants, foreign nationals, especially when it comes to uh, people who don't have any status. Now, putting aside about Congress, they do have work to do, but in the meantime, to help ensure the smooth processing of cases in removal proceedings, which means the official name is Executive Office of Immigration Review, aka Immigration Court. These priorities are very, very helpful for the judges really as well, and especially the Department of Homeland Security attorneys. Okay, in other respects, if it was like a regular civil court, which is this, it is a civil proceeding, they'd be considered like prosecutors essentially. So, anyways, so the top three things you need to look at here it is on. I'm going to share my screen. Okay, so you'll see that this was effective or not effective on April 3rd, but that's the date that this memo was issued by Carrie Doyle. She's the head attorney for ICE. Official name is Principal Legal Advisor. Okay, so you'll see here that later on I'll show you that the actual effective date is April 25th, 2022. So that is at the time of this show, that is about 6 days until that time. So you'll want to listen all the way to the end of the show so you can get ready and you can ask your attorney, set up a meeting with your law firm that you've hired. Or, of course, if you don't have one, we'll find a way. Our CARES team, once you call this number right here, 346-330-5888, and our CARES team will find a way to set up a time with you for a free 15 minutes, which we do offer the secret code at the end of the show. So please stay tuned all the way to the end. Anyways, showing you the three priorities issued by Secretary Alejandro Mayorkas. They call it the memorandum priorities. And that is number one, if a foreign national has been a threat to national security. That's a pretty obvious one. Have you been a spy before? Have you are a suspect of terrorism? Okay, to that level. And then priority B is actually one of the more common situations, and that's threat to public safety. So a common type of criminal offense is DWI. In some states, you can call it a DUI, drinking under the influence or driving under the influence or driving while intoxicated. So it just depends on your state. So, for example, there's a case law that says that two or more DWI type of offenses is a danger to society for bond. So that most judges are very unlikely to allow a bond release when there's two or more drinking related offenses. So this could really help in this type of situation. I allowed to argue it's not part of mandatory detention. So that's something to consider, okay? Also, even if you're not in detention center right now, or of course a family member is not in detention center, something like this can be helpful if it's only one kind of lower level offense, because there are some judges that will keep your case active even for one assault. Now, I know some people are in wrong place, wrong time, and there's assault happens, but even assault happens with loved ones, and that kind of crime does need to be reported. Okay. But of course, depending on circumstances, especially in light of this memorandum, this memo that's effective April 25th, it could be helpful for you. Okay. And then priority C, okay, this threat to border security. And this, what it means is, have you been a recent entrant from the border? Okay, meaning entering without legal visa. For example, visitor visa, B1, B2, or F1 student visa. Okay, that's just an example. But right here it shows November 1st, 2020. If you've entered any day after that, you would be considered generally a threat to border security. Okay. So just want to share that for now. And then, so let's say you don't meet those three different priorities. Okay. And even if you did, of course, your private attorney that you've hired will argue that you don't qualify under those enforcement priorities. Okay. Usually you will want to say you qualify for something, right? For a benefit. In this situation, you want to argue that you don't meet these priorities. That's step number one. The step number two, what is the action plan that we want the government to help us with? Okay, Department of Homeland Security. So now specifically is number one, for example, people ask, okay, well, if a person is denied for the 485 application for adjustment of status for whatever reason, maybe there's misrepresentation or even alleged misrepresentation or fraud. In some cases, especially during President Trump's administration, USCIS referred these foreign nationals, immigrants, to the immigration court, the Executive Office of Immigration Review. So they're saying step number one, if someone is not even in removal proceeding now, they're going to first see if even this is really a waste of time, essentially, for the court, for your case to go there. Okay. And they call that notice to appear. Okay. So I want to share my screen again. And so that's the first thing. Is it even a situation where then USCIS or any other agency needs to issue a notice to appear, basically saying, get your butt to court, okay? Appear in court. You do not want to fail to appear. So, by the way, friends, hot tip here: if for some reason you have been issued a notice to appear, you want to show up, okay? I know these days a lot of courts are remote, but some courts like Dallas, default thing is you have to show up. Okay. So I'm sorry, for Houston is a default that you have to show up. So again, like I just got that mixed up. You want to call the court clerk and verify that. Okay. Number two is, if you have a case in removal proceeding, can it get dismissed? Okay. Right. So that's something DHS attorneys are looking at as well. We've actually had a couple cases dismissed outright without us getting too involved. So that's a great thing. And part of that, I like to congratulate our team, is that we provide as much evidence as possible from the very beginning. Okay, friends, because I've heard of some situations that people are represented by other folks, and they just provide the bare bones type of package and evidence. And so I like to credit my team for getting it done correctly the first time around. Now I want to share with you the difference, though, okay, because of number two and three options. Because the second one I just mentioned is dismissal. Some people call that termination or the cancellation, essentially, okay. But the difference between that and administrative closure is that administrative closure basically saying your case file is still going to be in court, but it's going to be inactive. Okay. So essentially, if something happens, like you don't have to go to court anymore, but you get a DWI or some other criminal offense, they're going to easily be able to reopen your case. Legally, we don't call it reopen, but move it back to, yeah, actually, recalendar is what we call it. Okay. So reopening is if it was completely closed out. But an example like this, like some judges might not be as open to these different priorities, and they might say, well, okay, well, if you have a U visa application, we'll just go ahead and administrative close it, but we're not going to agree to dismiss it. So that's just an example, especially because U visa applications take a long time. Now, of course, as a private attorney, we're going to argue for termination. Okay. We want the best case situation for you. Another example could be for an I-360. Maybe some judges are just not open to that, to be terminated. Of course, again, we would recommend for termination to get it out of the court's calendar. And the fourth thing that the Department of Homeland Security can look at, ICE officials, is what we call stipulation, meaning making an agreement, whether to the relief itself, which is the best thing, really. For example, let's say cancellation removal. There's a couple different variations of that. One's for residents, permanent residents who already have that status. And for those people who are completely undocumented, don't have any visa, maintaining status. And the third one is, there's more than three, but the third common one is for Violence Against Women Act. Now, of course, you might not know this, but this is not gender specific, even though it includes women in the name, but it's also for It's really for any gender. Okay. So, anyways, Department of Homeland Security, if they see all information that's been presented to them by the private attorney representing the foreign national, they could be like possibly agree to just saying, sure, we agree to that relief and we're not going to appeal. So that's one of the other items down here is that it says pursuing appeal. They're saying because what on default right now they're doing is they're going to like what we do as private attorneys. We if we get a decision not in our favor, we use the phrase reserve appeal because we want to be able to speak to our client afterwards and say, do you want to take the next step to change that decision? Of course, if legally eligible to do that. Essentially, DHS is now going to be able to consider like we're not even going to reserve appeal or pursue appeals, essentially. Okay. And the stipulations to issues itself, for example, to avoid spending a couple hours about certain topics in a trial, for example, hardship. I've had a couple cases actually where the government attorneys agreed that when they're agreed that hardship exists in the case for the cancellation removal. So they're not even they're saying you don't even have to ask questions about it. So that was a wonderful thing in our cases, and we were approved eventually for that type of case. So number five, the fifth thing that DHS can agree to essentially is a continuance. So, for example, I just use the example of if someone has a U visa application pending or I-360 self petition VAWA application pending. This is a likely scenario that the government attorney and even the judge will say, sure, let's wait. Let's schedule your case 6 months out or even a year from now and see what is going on with USCIS. And of course, they're taking forever. Even before the pandemic, USCIS was taking a long time on a lot of cases. So, which we'll cover that in a separate video about the new processing time goals. Okay, so the other thing I want to share with you, friends, is so we talked about pursuing appeals, and the seventh one is about joint motions to reopen. Now, traditionally, by law and case law, is that if you want to reopen your case, you had to have some, you have to show that you were eligible for that relief back then. So let's say you had a removal case that was had a final order 5 years ago. You had to show that your eligibility for immigration benefit through USCIS was available at that time 5 years ago or whenever your removal case was. And I know you might be wondering, well, how is that even possible? Of course, I would have pursued it if you were eligible at that time. So what this is saying now, okay? Now again, this is just a memo. This doesn't mean it's going to be an automatic thing. But what we're recommending to clients is that we recommend to file a request to the DHS first, of course, after the effective date, April 25th, 2022, and ask them if they'd be willing to join a reopening of the case and maybe even termination of the removal case after it's reopened, right? Because we just don't want, we prefer not a situation where you have to show up to court, right? Just get it reopened officially and get it terminated at the same time. Essentially, provide a benefit of resident status to those who are eligible for it. So, for example, if you are someone who or family member who has entered America with a visa, and either you don't have to be married to a U.S. citizen, but if that is one of the family relationships, marriage to U.S. citizen, or you have adult son or daughter, it could be even stepchild relationship if the marriage relationship occurred before that person, family member turned 18. But if you have those relationships, that those are considered immediate relative. Okay. The third one is if your removal proceeding or you had an old case and your immediate relative category also is if you are under 18, okay, and your parent is a U.S. citizen. So that's usually the rare situation, okay. So because a person under 18 is, although they can be in removal proceedings, there's no unlawful presence for people under 18 years old in the United States. Okay. So, anyways, if you enter with a visa or you qualify for any of the limited exceptions for showing entry, okay, legal entry. For example, if we have a video about that. We'll go in more detail. But let's say, for example, you're eligible for military parole in place. This is something you want to consider, okay, and requesting your attorney or your legal team, the law firm, to pursue this memo. Okay. Make sure the first, as I mentioned, step number one is make sure that you are not, your facts do not meet those enforcement priorities. Okay. And then number two, if you can get your case dismissed. Okay. That's what we're pursuing for all our removal cases. So our legal team that's working on removal cases is will be looking at all our cases within the next 30 days. Okay. And prioritizing that. And if you have any questions, my friends, I want to share our secret code, okay? Because you can unlock the free 15 minutes preliminary discussion. And here is, my friends, it's on the bottom. You could have guessed it, especially if you've been following our channel and subscribing. It's Green Card Guys on the bottom. The best thing to do if you don't have time to call or text above, we also have WhatsApp with the same number. You can answer a few questions at our website. The link is down below. Okay, and this is what you can do. Okay, go to our website, greencardguys.com, go to the contact us page. Step number one, answer a few questions. And then step number two, you're welcome to self-schedule an appointment, or of course, our team will call you if it's on a weekday. Okay. So if you enjoyed our content, this gun went into real detail right here. Please smash the like button, give us the hearts on Instagram, and subscribe to our channel if you want to see this type of content in the future. Okay. And by the way, friends, if you are new to our channel as well, want to actually, for this, really for everyone, this is our TikTok Green Card Guys. Okay. I bit the bullet. I really was trying to avoid it, but I've been really encouraged by other attorney friends that, hey, John, get the account started. So if you're a creative person, especially, share some content. We love to like everyone's content. That's our clients, actually. So anyways, we greatly appreciate it. Thanks for tuning in, and stay tuned for our next episode. Thank you very much, and talk to you soon.